Hi, good morning.
Good morning.
All right, so we're going to talk a little bit about estate planning. So I'm going to give you a few kind of preliminary things to think about. One is everyone should have an estate plan. Now, what that plan is different, but everyone should have an estate plan. Everyone does not need a trust. We see ads and things that says everybody needs a trust, everybody needs a trust. Not everybody needs a trust. Trusts are wonderful tools. They have served great purposes, but it is not a known thing that everybody needs a trust. I simply just disagree. In many people's cases, the only thing a trust would do is avoid probate. And that brings me to the third little thing. Avoiding probate is not in and of itself a reason to exist. Probate is not a bad thing. I mean, it's gotten a bad name over all these years. When I first started practicing, probate was everything you had to go in front of a judge. Everything was very complicated. Attorneys could take percentages of estates as their fees, so even though they were doing the same amount of work. But all the laws have changed. So probate, frankly, if you have a will, a basic will, a probate will take anywhere from 6 to 14 months to administer. There's no inheritance tax in Illinois. The courts just don't take your money. The state's not taking your money. It's a very kind of nice process. You have somebody appointed and that person's in charge. So, and avoiding probate, the only advantage to that is you save some of the attorney's fees and costs at the time and a little bit of time in administering. So we'll talk about options around that. And it's not the worst thing to try to avoid probate, but if your trust is only going to avoid probate, it might not be worth your while. And it depends what estate assets you have. So we'll talk about all that. So what I'm going to kind of start with is, the original basic plan is, you do a will. All right, so what does a will do? A will, you set forth what it is you want to do with your things when you pass, right? A lot of my estate planning with spouses, married couples, we do reciprocal wills so that each will says, in case of one spouse dies, the other spouse gets it, and then on the death of the second, off to children or whatever else is the backup plan if you don't have children. So that's kind of what the will says typically, and a basic will just then provide for whatever it is you want to do. You can give specific bequests in your will. You can not give specific bequests and just say, I'm going to split everything up among these certain people in certain percentages. So all of that stuff can be done in a will, and the will is a basic document. It's witnessed. The statute says how it has to happen, a witness. We have witnesses in minority, and we take care of drafting that, and then the original wills go in your hands, and then you have to keep them safe because the original wills are important. They are the ones you have to have. Copies of the wills don't really help you very much. There are ways to try to deal with it if you only have a copy, but you want to keep your original safe. So that's one option. And now, of course, if you have a will, and that's the way that you're going to manage your estate plan, then there would be a probate. And then what that means is that upon your death, your will is filed in the county in which you live, and then a probate petition is filed asking the court to appoint whoever is the executor in your will. Typically in Cook County and Will County, you get those petitions filed within 30 days. You have a court date, and that court date you typically get the person appointed. And then at that point, the person is now got what's called letters of office. And the letters of office then give them kind of the keys to the palace. They can do anything. They can do anything that the deceased could have done. They get access to their accounts, their IRAs, their safety deposit box, whatever it is that needs to be done. The letters of office would give that person the authority to do that. So then, again, in that concept, then once you get your letters of office, the executor takes steps to administer the estate, paying valid bills that have to be paid, liquidating assets, cleaning out, selling a home. So out here typically, there'll be a home and some investment accounts and some retirement, some bank accounts, things like that. And so that's kind of a common thing to have to deal with cleaning out and then selling the home. So you only have to wait in a probate 6 months. You have to wait because there's a claim period. And that what that does in a probate estate is it provides that anybody who thinks the decedent owed them money has 6 months to file a claim. So, I mean, if you know about a debt, you have to honor it, but if you know, in order to close it, you have to get through that 6 months. But, you know, a lot of times if you're cleaning out and selling a house, you've got that much time generally anyway, you know, to get it all done, get it sold, and administer and distribute. You'd open an estate account, we would typically get an EIN number for the estate, and then the executor just administers, takes care of business, eventually gets all the assets put into an estate account, and then distributes according to the terms of the will. So, and then once we do that, we have papers that the recipient sign, and then we go back into court whenever that's done and close the estate. So it's a pretty simple process. Now, a couple things to know. Illinois has no inheritance tax. Okay, that they had one about 50 years ago, and that was the last time. So we've had no inheritance tax. So these assets are not going to be taxed as an inheritance. Second thing to know, in most cases, what will happen is if the asset is being transferred over to a legatee under a will, there's what's called a stepped-up basis. So let's say mom and dad had a house and they've had it for 50 years and they bought it for $30,000, and now that house is going to their kids. The basis for the house for any potential capital gains issues is going to be at the time of death of the second of the parent, right? So that's called a stepped-up basis. So you're not dealing with capital gains. You know, you really don't have to, you're not getting mom and dad's basis in the property. And if you now sell it for $300,000, you're not having to pay tax on this $270,000 gain. You get the stepped up basis, meaning the value of the home at the date of the death of the parent. So they're really, and in most cases, if you are just planning to, you know, clean up and sell the house, you're not going to have any gain from that time. It'd be different if you're going to maybe keep the house and rent it out for 10 years or something, if that's what the legatees all decide they want to do. And in that case, you would have gain, but your gain would be from the date of death forward, not all the way back. So that would just be that. So you don't have really any significant capital gains. The other issue is out there is there is an estate tax. Illinois has an estate tax, but it's only on estates over $4 million. Okay, that's currently. So now the interesting thing about that is it's not on the amount over $4. If you have $4,001,001, you are going to be subject to the Illinois estate tax, and it's going to be on the full $4,001,001. So, and the rates on the Illinois estate tax, they start at 0.8, and that would be the case of the $4,001,001. You'd pay a 0.8%, all the way up to 16%. That's the highest rate available on the Illinois estate tax. So, obviously, that comes into consideration, and we'll talk about what we want to do in other estate plan options to deal with that. The federal government has an estate tax, which as of 2026 is up to $15 million. So again, and that has what's called portability. So with a husband and a wife, so if you split up the husband and wife's assets into, you know, if you have a $30 million estate and you do trust and you put $15 million in wife and 15 in husband, that you can get, and then wife passes, then that portability of her exemption level can roll into the husband's, and they get $30 million worth of that. So the feds have portability, the state does not have portability. Again, that all comes into play when you estate plan. It's very important to find out what assets, you know, the parties have and how they're titled and how we do it. So, so that's kind of the tax issues associated with that, and that's, so, you know, if you're fortunate enough to have a $4 million or more estate, you know, you now have to estate plan for that. I mean, and there are ways, especially if you have the feds and you have the $15 million estate, there are ways to estate plan. One of those ways is to do trusts. So I'll kind of go into trusts in a minute. One other thing I like to do, and it's another way to estate plan, is just title. So you can title things. So if you have a relatively simple situation, husband, wife, 2 or 3 kids, and you intend that you want everything to go to the kids, you have 3 adult children, and one of the things you look at is, you know, things such as, do any of the kids have addictions? Do any of the kids have disabilities? Any reason you would not want money to go directly to that child. But let's assume we don't. Let's assume we just have a husband and wife, 2 or 3 kids, and the kids are all adults and with no disabilities. And you can title things, so you can name beneficiaries on accounts, and that will control that asset. So if you have a joint bank account, you can put the 3 kids on as beneficiaries, and upon the death of the second of the parents, the money just goes to the kids. You have an IRA account or an investment account, same thing, you can name beneficiaries, and that will control. You can do a will that says everything goes to me, but if you have beneficiaries named, that's where it's going. So that will control. So that's a very good estate plan technique, is to title things when appropriate. You know, and that's something that I usually do in conjunction with wills, is we talk about estate planning. We do wills, and we will then, you know, often implement some titling as well, so that with the goal being that we hope to maybe avoid having to do the probate down the road with the title. Okay, so that's a kind of a nice way. Now, another thing Illinois has now, and it's relatively new, they have a thing called a transfer on death instrument. So it used to be that you couldn't deal with your house any other way but through a trust. Otherwise, the house was going to go into probate. That was always the deal. So, so you'd have to do land trusts, which you may have heard of, or revocable trusts. But now they have this transfer on death instrument, which is a nice tool. It allows you to put beneficiaries on your house. So, and you record a document, a deed, just like your deed or your mortgage is recorded with the recorder of deeds. So it'll say that in the event you still own this house at the time, if it's husband and wife, the second of you passes, it simply just now is owned by these 2 or 3 kids or whatever you got, you know, whatever you've done. So it's really nice, and it allows you to name beneficiary on a house. Now, then it doesn't give the kids any current interest, so you don't have to look to them or ask them if you want to sell and move to Hawaii. You don't, none of that. The house is still yours, 100% to do whatever you want to do with. But the only drawback with the transfer on death instrument, which can be a problem, is it will then have your kids own, let's say you had 3 kids. Each kid will now own 1/3 of the house, and they'll own it right then, as soon as the second parent dies. Now, that may not be a great idea. You know, you might have a couple of kids that are doing real well and are willing to pay their 1/3 of the taxes and the insurance and cutting the grass and paying utilities. You may have one that isn't excited about doing that. And sometimes these days, kids are moving back in with their parents. And you might have one of the 3 kids is living with you. Well, that sure changes the dynamic on what everybody wants to do with the house when mom and dad die, right? If one of them's living there. So I always talk about that with clients, because sometimes a transfer on death, it's a good tool, but it's not a great tool in some instances. And you may have a situation where you're just creating more trouble than if you just went to probate, named some kid in charge, and that kid's in charge of taking care of the house. They're gonna sell it, do whatever, and handle it. So, but the TOTI is a great option, but it has its limitations depending on circumstances. And that's one thing about estate planning. You know, I came home the other day and my wife says to me, well, I heard on the radio today that you can do estate plan in 30 minutes on over the internet. Somebody was telling. I said, yeah, we'll go right ahead. Go right ahead. The problem with all the fill in the blank things that you'll see that you think are out there, every estate plan has different nuances. I mean, just exactly what I mentioned. Your kids are all a little different. I mean, it's not like, you might have 6 kids, and 6 kids in a TOTI is a terrible idea. I tell people almost, listen, if you got 6 kids, don't do the TOTI. I mean, it's just impossible to believe that you're gonna get 6 kids that are all gonna agree and cooperate. I mean, it's unusual, so, and then the other issues are you have, with respect to your children, you have to decide what you would do if one of your kids predeceased you. And so, I guess what, and that's all things you do in a detailed, elaborate estate plan, right? I mean, you don't just fill in the blanks and run off. And You know, it's just, it's a mistake. You know, you're better off, it's not like this stuff is so expensive to go see an attorney and get an estate plan and something that will fit your needs and meet what you want to do. So I do kind of laugh about those things. I'm not a big fan, as I really think that somebody then does one of those things and thinks they're okay, and they're really not, you know, and then somebody dies, somebody becomes disabled, all of a sudden they think they've got the right paperwork and they don't. And now it's too late to do it right, and it's a mess. I mean, so it's not a great idea to just go fill in the blanks. I mean, it's just not a great idea. So let's get to the kind of big one, the trust. So if we decide that we think a trust is the right idea. Now, trusts can be great tools, because what a trust does is you basically put your assets into this trust. That's called funding the trust. We create a trust, we fund it, and now the trust has certain trust assets. And even if mom and dad die, the trust is alive, the trust survives. So the trust still would own it, and now just have named another trustee who's gonna manage, and different beneficiaries who are gonna benefit from the value of the assets. So the trust, and then through that, you do avoid having to probate, file any kind of a probate. So it absolutely will accomplish that goal of avoiding probate. But the trust can be done as an estate planning tool. So let's say you do have $6 million as a couple. Now, how are we gonna deal with that? How do we figure out a way to avoid the Illinois estate tax? Well, you do what's called, basically, AB trusts. You do a trust for each spouse, okay? And then what you do is you fund it with approximately $3 million or so. You don't have to do it to the nickel, but your goal is to keep both trusts under 4. And then when the second the person dies and the stuff's gonna go to the children, they're coming from 2 different places and they're both under 4, and you've avoided the estate tax, Illinois estate tax. So that's what the trusts do. When I first started practicing it, when the exemption level was $600,000. So the AB trusts were very, very popular then, because, you know, life insurance, a house, and even though the houses weren't worth as much then, but, you know, the point is you still could get to 600,000. You know, 4 million is a pretty big number. You know, I mean, you can get there, but that's a solid number. And 15 million is a very solid number. But back then it was, you know, it was 600,000, and so you could, they were very popular then, especially if people were early in their lives and wanting to, you know, stay ahead of the game and make sure that, well, you know, my assets are gonna grow, so I wanna make sure I get it. So we did a lot of the ABs. Eventually, as the exemption level rose, then if you don't have the estate tax issues related to your trust, then your primary purpose of the trust will be, you know, there's some discretion in it because obviously nothing will get recorded. There'll be some privacy to it, you know, as opposed to a will wouldn't be recorded and somebody can look it up if they wanted. But the other thing a trust does, if you do have a child maybe with a disability or an addiction, or somebody who's down on their luck, business issues, they don't have, their money situation isn't so good, and you want to try to, you know, protect that a little bit or help that person. The trust, you can kind of make the trust handle it how you want to handle it. So you can provide beneficial interest. You can say, I'm going to give it to the kids at 25, 35, 45. You can set things up for you know, segmented distributions, and you can control distributions to a child that you think, you know, maybe is not a good idea to get money to directly for whatever reason. So they're very helpful, and they will avoid probate. Now, a couple things about that is you don't put retirement assets cannot be titled into your trust, because the IRS has determined that if you transfer a retirement asset from your name into your trust, they deem that a taxable event, so they'll hit you up with the taxes. So what typically happens then in a spousal situation, we just leave all the retirement assets as is. So husbands would then name wife as beneficiary, and the wife's retirement would name husband as the beneficiary. After that, you can kind of do it either way. Depending on your situation, you could then name your trust as the contingent or secondary beneficiary of the retirement assets. or you could name kids if you were comfortable with that. And one of the things the IRS also did, again, years ago, it used to be that if parents passed and kids inherited an IRA or 401k money, they could roll it into their own that they had existing, and then not have to pay any tax on it until they took their distribution. So if 40-year-old kid was inheriting the retirement from mom and dad, they could wait till whatever the age, 30, 33 more years before the feds were getting their money and any of the tax from those retirement assets. IRS got involved there and decided they have a 10-year rule on that now. So basically, if you don't get to just wait till whatever you're going to do, you're going to pay. If it's not sooner, you're going to pay at the 10-year mark. You're going to start paying the tax on the money that you got from the parent. So, but it is what it is, But that's the rule on that. So the other interesting part of a trust, if the bulk of your assets are in your retirement account, you can't even put that in your trust anyway. So then the question is, well, all right, is the trust then, I'm already avoiding probate because I'm naming beneficiaries on that. So now, what else do I have and how else do I want to do that? And maybe you use the TOEI. So sometimes we end up just do titling, transfer on death instrument, have a will out there, but really plan that the estate plan is going to be the naming of beneficiaries and the transfer on death instrument for a modest estate. And that's, a lot of modest estates out here where I practice, and a lot of my clients come in, and that works for a lot of them. It really does work quite a bit, for a lot of people, and it's certainly a lot less expensive from an attorney fee standpoint to do, basic will, just instruct the client on titling, and then do the transfer on death instrument. If you sell the house and you buy another house in Illinois, you just do a new transfer on death instrument for that house when you do that. So if you do move, that's how that works. So I guess the bottom line is, estate planning is very unique to each person and each situation. You could be a widow or widower, and your spouses, you have kids, how many kids you have, where they are, what they're doing, do they have disabilities, do they have addictions, do they have any reasons you don't want them to. So there's a lot in play. You also want to analyze whether, if one of your kids predeceased, do you want that money to go to their kids if they have kids? Or do you want it just to go to the surviving children? That's another decision that we make when we talk about estate plan, that when we work with it. And again, when you're doing the fill in the blank stuff, see, some of those nuances just don't get covered. And so I just feel like you don't get everything done quite right. It might work in some cases. If you're like exactly the cookie cutter situation, those things might work. But anybody, if you have any kind of things, it's so much worth it to sit and talk with an attorney and go over your assets. What are your goals? What are you going to be doing? Where are you in life? If you're 65 or 70 and you're close to starting to withdraw, are you 40 and you could start earning more and you may double your assets by the time you hit retirement? So all of those things come into play when we talk about what's an appropriate estate tax plan. If I get a younger couple in and they've already got a couple $1 million, I start talking about those AV trusts right away. Let's just get in them. There's no downside, no real downside other than the expense initially of setting them up. But then you have these people, they can grow into their trust and continue to add assets into their trust. It's extremely important. I've also had many clients over the years that have gone to estate planners who, convince them they have to have a trust. Charge them, who knows, $5, $6, $7, $8, $10,000. They come out with a spiral notebook like this with all kinds of stuff that they don't understand. And then one day they come into my office with their big spiral notebook and they say, I don't even know what I have. What do I have? So we start looking. And the trust is drafted perfectly fine, but the attorney didn't take steps to make sure that the assets got transferred into the trust. So a lot of times clients come in and they still have bank accounts in their name and their investment accounts in their name, and it makes me angry. It makes me very angry because it's just wrong. estate planning and trusts ought to, that gotta be a piece. It's meaningless to draft a trust. You know, as much as I can draft it and do whatever, if we don't put assets in it, this is your trust. And everybody has the same trust, because it doesn't matter, it's useless. So it angers me when I see that. I also see a lot of people come in who have been advised they have to have a trust, they have to have a trust. And it'll be I had a woman the other day, elderly woman, she had her big notebook, and all she had in life was a bank account with about $15,000 that her Social Security and pension went into, and a house that didn't get put into the trust. I mean, even if it got put in the trust, I might have said, well, okay, I mean, you did at least do that. But there were so many other options for that one. But yeah, and then you get it. So the two parts of the trust. Now, so they will avoid probate, that they absolutely will. I'm just saying to you that avoiding probate is not in and of itself ought to be your lone goal in life. I mean, it is simply not that bad, and it's got so many positives to it. It's just not that bad. It doesn't go on forever. It is not so costly. I mean, our typical probates, if we had a simple probate come in, it's about $2,500 in costs. I mean, it's just not prohibitive. And so I think, you'll see marketing, you see attorneys do marketing and they'll tell you gotta have trust. But of course, the attorney makes more on the trust. So, it's worth their while to tell you that you need a trust, because then when you do a trust, they make more money. It simply isn't the case that everybody needs a trust. Everybody could have a trust, but you pay up front for it, it's more expensive, and then it doesn't necessarily, there are other ways to do it. In a lot of cases, there are other ways to do it. In some cases, there are not. And when there are not, and the trust is the right tool, it's an excellent tool. And it should be considered and done, and then that will be a great way to do your estate planning. A couple other things. The gift taxes. So we talked a little bit about estate taxes. So the exemption levels, and this is just to kind of clear up what the gift tax and what that means. The exemption levels, so state of Illinois has the 4 million, the feds have the 15. The reason they have gift taxes and gift tax returns to be filed is they don't want somebody with $25 million just giving away $10 million and then not having to deal with a gift tax. So they say, okay, if you do a gift in excess of the amount that's allowable by law, and I'll explain what that is, then you have to file what's called a gift tax return. So if you do give $1 million, to one of your kids now, you have to file your gift tax return. And all that happens is your exemption level drops down from 15 to 14. So you aren't going to get the benefit of that as to the taxing at the end of the day for estate tax purposes. So you don't pay a tax on the gift tax return. It's to notify the IRS that you have given a gift and reduced your exemption level according to the amount of the gift. Now, another really good estate planning tool is gifting. You can gift now up to $19,000 per year per person. So if you're at a stage in your life that you can quantify pretty good. I'm in good shape between what I got coming in, what I have there. I'm at about 5 million. I want to start getting that down so I can maybe avoid the $4 million Illinois estate tax. You can start gifting, and you can gift. If you have 3 kids, you give them all $19,000 every year. You can just start gifting, and it's a legitimate way to, and you don't have to file any gift tax returns if you're at that amount or less. So that's a nice way to deal with getting your estate down to a point that you can hopefully then otherwise avoid. So depending again where you are on finances, but that's a nice tool, and you can do that. It's currently at $19,000 a year per person. So you could give 5, 6, 7 people, whatever as long as you're giving different people the 19 grand, you can do it. And it comes right off. The estate is lower, no gift tax returns, and no adjustment on your exemption levels. So it's a legitimate means of kind of getting your estate down. So that's a nice one. The other estate planning, beneficiaries. Obviously, you have joint tenancy things, and husband and wives typically will own things in joint tenancy. that means that when one of you passes, the other owns the asset entirely as a matter of law. Done. No, nothing has to be filed, nothing has to be done. It's just, that's what a joint tenancy does. I'm not a fan, and I've just simply never done this for people. Occasionally we'll have somebody come in and say, you know, I'm getting older and I wanna put my kids on my house, so, or give my, you know, kids my house so that if I go in a nursing home, they can't take my assets. I just simply won't do that, because at the time you do that, you no longer own your house. And, you know, you can think your kids are gonna trust them, but, you know, what if one of the spouses dies and the other one meets somebody new and they wanna, there's so much that can go wrong with putting your kids, you know, giving your kids your house. You know, I've had people come and ask me that, and I just won't do it. I said, listen, somebody might do it, you'll find somebody else who might do it for you. But I'm never gonna have somebody come back and knock on my door and say, Dave, you put my house in my kids' names and now they've kicked me out or they won't let me sell it and I'm gonna move in with you, right? I've never had that happen because I will never have that happen because I don't do that. I just don't, it's just, because to me the worst case scenario is you have to use some of your own assets to pay for your own care down the road. That's not really a terrible, I mean, you know, you'd always like to leave things for your kids, but if the worst case scenario is your assets get used to pay for your good care while you're alive, that to me is not a really terrible result. You know, I mean, but everybody wants to leave some things. So talk a little bit about probate. Now, other thing I want to chat about a little bit. So we went through these trusts, and so the other thing we can do, let me bring this up, the other thing we can do, I mentioned the AV trusts, and those would be the trusts that we would use if we're trying to actually address, you have over the exemption amounts and you want to split your assets up a little bit so that you can stay under the exemption level. But if you're not there, if you have $1 million and you got a house and some assets and some investment accounts, but you still want to do the trust. Maybe you have a child that's a little down on his luck or you know, is struggling and you don't really know that it'd be a good idea to give him money right now, and you have some other reasons. And we do a trust. A lot of times we just do a joint trust. When we first started doing these, they were frowned upon, but they're far more common now. And then just do a joint trust because you're not trying to do, you don't really need the AB trust because you're not actually trying to deal with exemption issues or estate planning or estate taxes. You're just trying to avoid probate and otherwise control the distribution of assets, and that's really helpful. Second marriages, stepchildren, you know, things like that come into play a lot. That the trust can be very helpful in how you're going to handle, you know, and then how we fund the trust with certain assets. Sometimes we'll leave second marriages. We'll leave some assets, maybe a life insurance policy out, and let that go directly to the first set of kids, so that you make sure you always provide for them, and then so there's just so many ways you can kind of play with that. But so that's kind of the trusts. Are useful and very helpful. They will avoid probate. They can help you with estate tax planning, and they otherwise give you a little bit of privacy. Other than that, you know, avoiding probate thing is what everybody tries to sell you on, and I just can't overemphasize. That's just not a huge issue. I mean, probates can get complicated if you don't have a will. They can get complicated if you had 6 kids and you wanted to disinherit a couple of them. You know, those things can be complicated because if you don't have proper estate planning documents, then you very well could end up having a result you don't want. And a probate like that can be very complicated. And estate taxes can also impact. The reason that the Wrigley family had to sell the Cubs years and years ago to the Tribune was estate tax planning, estate tax issues. The original owner of the Cubs, I don't remember all their names, Bill maybe, I think was the original one, but anyway, the original owner of the Cubs passed, and it went on, he had his 2 kids, but the kid he put in charge of everything died kind of unexpectedly at about 55. So they didn't, and all that at that point that that family had at that point were the Cubs. They didn't really have money. they had the Cubs. It's kind of like the Hallis family and the McCaskies. A lot of those kids, they don't really have money. They just have a share of ownership in the Bears. So in order to pay, and since they didn't plan accordingly, they had huge estate tax that had to be paid by the estate, and they didn't have the money to do it, so they had to sell the Cubs. So that was kind of the reason for that. But so probates can be complicated. I mean, you know, you have, if you don't have a will and you have two people and a husband and wife and their second marriages and they die in a car wreck, well, who died first? Because without a will, it's going to go to the heirs of the survivor. You know, so you could have those kind of probates can be a nightmare. But if you plan with a will and set up your titling, your probate is simply not going to be a problem. Even if you have to disinherit a child or two, we put the language in there, we make it clear that they are choosing to disinherit this person. We don't go into any details. I'm aware I have this one son or daughter, but I'm choosing not to provide. Or maybe they feel like they've already provided. Sometimes, you know, sometimes parents are giving one of the kids a little bit of money along the way and has chosen not to do that. So even with that, your probates they're pretty smooth. And so just don't get sucked into that part of it, that you know, probate is this evil black hole that everybody needs to avoid at all times. So aside from then the estate planning part of it, you also have these powers of attorney. Now, as much as I say everybody needs an estate plan, everybody needs these powers of attorneys. Because the concept here is, if you are alive but incompetent, who's gonna make your medical decisions? And then there's another separate power of attorney who's gonna make your financial decisions. Different hats, right? Different skill sets. So, you know, you may have, if you don't just pick in the order of, you know, oldest to youngest or something, because on the health care, for example, one of the things that the agent on a healthcare power of attorney may have to do sometimes is pull a plug, right? Or stop treatment and let mom or dad pass. And I guarantee you, you all in here will know, if you have kids, you probably have one that won't do it or couldn't do it, right? And so, or some that would maybe rush to do it, but yeah, certainly they're all different. So you have to think about, you know, and so there are different skill sets. And so when you're picking who's going to do those things, so typically in a husband and wife situation, they're first, and then you have the backups. We don't name so you have to name a person, and part of the reason for that is to avoid litigation. You don't want to name two backup kids to be making decisions once the parents are out, because then they could disagree and now you got litigation, and it was one of the points of the Power of Attorney Act, was to avoid the litigation. And so there will be, you know, a first choice, a second choice, a third choice, and I always love to have at least two after the husband and wife. If you're a widow or widower, then I like to have at least two, you know, three then total, so that we can do this document and at least trust that it should last a while. You know, so even if one person passes or is not, you know, moves out of state or somewhere and is no longer viable, at least you have others and you're there. The healthcare power of attorney basically does what it says. It allows you to make medical decisions on behalf of the principal that the principal could make if the principal were competent. And we typically, those can range anywhere from treatments to nursing home, going into nursing homes. We have drafted, kind of over the years, we determined that there were some holes in that, and in the healthcare power of attorney, one of the holes that we found is, if you call a health provider on behalf of the principal, and you're chatting with them about a few things, and then you say, well, listen, and by the way, I saw this big bill come in, and how come that didn't go through insurance, and it should have gone through insurance? Can you look that up and talk to me? And they'll say, out. HIPAA. No, not even HIPAA. It's the power of attorney only provides for medical decisions, not, you know, and dealing, and so they'll argue, well, that's billing. You shouldn't. So I literally just have an addendum that I put on my powers of attorney that says, not only are we going to deal with medical providers, we can also discuss and resolve billing issues. So I put that in there so that it's just one of those things that we found over the years was just a little bit of a hole. Because it's kind of natural, even if you're not necessarily disputing it, or you just want to find out about it. I mean, administrators and healthcare providers were just stopping the conversation there. So that's that, and so we create those. You mark in the power of attorney when you want it to be effective. You can have it effective on a doctor putting something in writing that says that you're not competent. You can make it effective immediately if you so choose, and basically just say, well, it's effective now, but as long as I'm able, I'm going to keep making my own decisions. And as a practical matter, if you're competent, you go into a hospital or go see a doctor, they're not going to ask your agent. I mean, they're going to talk to you, so you're fine. Now, the other power of attorney is the financial power of attorney. And obviously, you got a different set of skills and who's going to manage your finances. Could be anywhere from paying bills and collecting money and rents from a business or managing a business for you, whatever the case may be. That person, again, would get involved and be able to, with the power of attorney, manage your affairs. And again, this is when you're alive but incompetent. So once you pass, the power of attorneys are out. They're done. They're null and void at the time you pass. They terminate on death. It's just for while you're alive but incompetent, and that's when you then use the financial power of attorney. Similarly, the form power of attorney with the state has kind of generalized thing, real estate transactions, this, blah, 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 blah. And again, over the years, we've kind of determined, we thought were some holes, some things that were missing, some very specifics. We have some language so that if you do have a trust, we deal with, let the power of attorney, whatever rights and powers you might want them to deal with respect to the trust. We have for Social Security, we specifically will authorize the agent to arrange for a Social Security payee, if you ever had to get into that situation. So there's some things in there. One of the ones is the person has to move from their house and go to an assisted living, right? And so you're going to change their address. So you take your power of attorney, you go over to the post office, you say, hey, I want to do a change of address for this person. They say, sorry, the power of attorney doesn't say you get to do that. It doesn't specifically say that. So now ours does. So we've just over the years, just things that we've just determined. So we've got a rider we attach that just handles a lot of things that might be kind of in between the cracks that you might, because you don't want hassles. If you're going to be the agent managing the affairs of somebody, the last thing you want is our roadblocks, right? If you go talk to somebody, they send you away. You gotta go figure something out. You want to just be able to manage the person's estate the best you can while they're alive and under those circumstances. Typically, with the power of attorney for finance, I will typically require or strongly suggest that it be triggered only with the doctor note. I mean, my position is that, again, I'm pretty risk averse, and I don't like the idea of a live financial power of attorney, because theoretically, do anything. You can go to bank accounts, you can literally, somebody go on vacation, you could put their house up for sale. They're theoretically, and obviously choosing people that you don't expect to do that, but I just feel like there's just never anything financially that can't wait a couple of days to get a doctor's note. And so go get if mom or dad are really incompetent and you need to take over their financial affairs, get them to a doctor. Get the thing in writing that says he's incompetent, not able to manage your own affairs, make financial decisions, blah, blah, blah. And now, with your power of attorney and your doctor's note, you should be able to go do your thing. So I generally in those, sometimes if I have, quite an older person come in and maybe one of the kids is already managing or doing 90% of their stuff, I might make it effective immediately. But for most people, I like to have that little bit of a extra little security there to make sure that we need a doctor to get involved. I don't do living wills. So a little quick history on it. So the living will was kind of the first step to deal with what do we do when a person is lying there, they're basically dead, but they're being kept alive intravenously or on just getting fed through the IV, or they're on a life support system, but they're brain dead. They're never ever coming back. And so one of the first things they did is they created this living will, and it was a separate thing in the statutes, and most of the states had them. But they're very specific. You know, they say, in the event that, you know, somebody's in a coma, their death is imminent as set forth by a doctor, you know, and they're being kept alive, you know, and it's very, very, very specific, then you can pull the plug. So it was too specific, and the powers of attorneys for healthcare basically are broader, and to me, anything that you would have thought you could have done with this living will, we can do with your agency in the power of attorney for healthcare, and more so. So we don't have the limitations of the very specific structure of the living will. And because I want to leave it up to the agent to make a final decision when to do something and how to do it based on whatever instructions the principal has given, I actually even kind of think that the living will could be a conflict with the power of attorney. So I just don't do them. I mean, you don't really need them, but you know, everybody kind of hears about it. And it's one of those things too. You know, I should have a living will. I should have a living will. What you really need to have is the power of attorney for healthcare. I mean, that's what you need to have, and make sure you have that. And then the other part of that again is you always got to have the conversations with your agents, right? To tell them how far do I want to go, right? I mean, I don't want this. I don't want that. If you know things like that, I don't want to be intubated. I don't want an autopsy. I don't want. If you know those things, I put them right in the power of attorney. So. But either way, you should talk with your agents on the healthcare one and just kind of explain to them. Just make sure they feel good. If they're ever in that terrible situation, I mean, I've had people come back in that situation, and it's much more comforting when you know you're doing what mom and dad would have wanted, right? Versus, I don't know. I mean, you think they wanted? We should have done this. I mean, the kids. It's just, you know, you take a terrible situation and somehow make it worse, right? So I think it's important to always have those conversations. And again, I would, you know, when I do estate planning discussions with clients, I make sure I tell them to go have those conversations. They don't like to have them, but I like to have them, tell them to do them. That's kind of the crux of my presentation.